Hello and a warm welcome. I'm very much looking forward to discussing the advisory opinion of the International Tribunal for the Law of the Seas with our wonderful guests today. I'm Marie Biermann, Managing Director at the World Future Council. I'm also a lawyer with expertise in the law of the seas, and I'm inspired to see how climate change is impacting the legal structures that protect our commons, especially the high seas. This year, in May, the International Tribunal for the Law of the Sea in Hamburg has made history with its advisory opinion in the fight against climate crisis. But the small island states bringing the case, for them, it was more a battle for their own existence. Let's step a little bit back, and I will briefly tell you how this decision came about. It's well known that states that are least responsible for the climate crisis, like small island developing states, are most likely to bear the worst effects of climate change. The oceans and the climate are closely linked, and that has dramatic consequences for the ecosystems, but also the oceans helping to mitigate the climate change. Less known has been the link between climate change and the law of the sea, which has only become more prominent with the establishment of a dedicated body in 2021, the Commission of Small Island States on Climate Change and International Law, COSIS. Faced with the existential threats of the climate crisis and the inaction of the world leaders, it was necessary for them to combat this fight against the climate crisis themselves. And so it was COSIS that eventually brought the case before the international courts. The request to the tribunal in Hamburg was to clarify states' obligations related to the protection of the marine environment and climate change under the United Nations Convention on the Law of the Sea. We, as the World Future Council, are engaged because rights of future generations and nature are key to our theory of change and work. Several of our counselors are leading the international work to address this challenge to the environment. And today we will have a chance to talk about this very important approach. And I'm very glad to introduce our speakers and moderator to you. I'll start with Naima Te Maile Fifita, who is member of the Commission of Small Island States on Climate Change and International Law, and also the World Future Counselor. Welcome, Naima. We also have Samira Ben Ali from the World Youth for Climate Justice with us, and also a warm welcome to you. Third in the group is Neshan Gunasekera, fellow at the Raoul Wallenberg Institute of Human Rights and Humanitarian Law in Sweden, and also a World Future Counselor. The conversation will be held by Lena Dente, who leads the climate and just transition work at the World Future Council. Welcome, Lena, and let me now hand over to you.
Thank you very much. I also look forward to this discussion today with all of you because it will help us put these decisions and these efforts into a context that more of us can understand. And Naima, maybe let's start with you, because you, in many ways, you represent all small islands, both as a small islander and as an activist in this space. And so if you could tell us a little bit about what your motivation was for being involved in this topic, and what's the impetus for action, what was COSIS's goal in bringing this to ITLOS, and how does this all work together from your perspective? Thank you.
Thank you, Marie. Thank you, Lena. So honored to be with you in this space and with other experts in this field. As I was introduced, my name is Naima Te Maile Fifita, and I'm from Tuvalu and currently reside in Honolulu, Hawaii. My grandfather is from the islands of Nukvatau and Funafuti, and my mother was born in South Tarawa in Kiribati. My family is scattered across the Pacific, from the Marshall Islands to Aotearoa, and my background is in international environmental law and indigenous rights. And specifically, I focus on the development of just and culturally responsive climate migration policies for Pacifica communities facing permanent displacement as a result of anthropogenic climate change. So before I start, I also think it's appropriate to acknowledge my ancestors' role in inspiring me to do this work, because their stories, it's really their stories of resilience and Tuvalu that have guided me, and I'm grateful for their support. In fact, a piece of my name, Te Maile, is actually an island where my grandfather used to spend much of his time as a boy. And it's now completely inundated, uninhabitable. So just carrying all of this with me. So your question pertains to my motivation in or my motivation for involving myself in this case and in this work as an islander and activist. It really boils down to wanting to protect our ancestral homeland and future generations from the devastating impacts of climate change, such as sea level rise, coastal erosion, and extreme weather events, and to advocate for the rights of these island communities who are disproportionately affected by climate change, despite contributing the least to the problem. And by now, I think we know this is true. Science has said this is true. Now the law has said it's true, international law. And so as much as we can, or as much as I can, I feel the need to raise awareness of the unique challenges faced by island nations in addressing climate change, and to amplify their voices on the international stage, and to promote climate justice and ensure that the global response to climate change takes into account the needs and perspectives of these island communities. So COSIS was founded on the premise that states who are least responsible for climate change will be the most likely to bear the brunt, or are bearing the brunt of its impacts in the short and long term. And so two governments, the government of Tuvalu and the government of Antigua and Barbuda, signed an agreement establishing COSIS in 2022, just after COP26. And later, the Republic of Palau, Niue, Vanuatu, St. Lucia, and the Bahamas, and other small island states joined. And I'm using small island states because that's the phrase that is typically accepted, but we don't see ourselves as small. But in any case, COSIS is now comprised of 9 countries in total. And so its mandate is to promote and contribute to the definition, implementation, and progressive development of rules and principles of international law concerning climate change. This includes obligations of states relating to the protection, preservation of the marine environment, and the responsibilities of states who commit internationally and environmental wrongful acts. So I joined COSIS as a representative of Tuvalu, and was able to attend the oral hearings in Hamburg earlier in September with my family to share some of why this mattered to Tuvaluan people and island people, and why this advisory opinion mattered to me personally as a Pacific Islander and as a lawyer and as a mother. So yeah, I hope that answers your question, but I think, these COSIS member states are actively seeking guidance, not just from ITLOS. Now we're looking to the International Court of Justice and the Inter-American Court of Human Rights, but we're trying to find answers to these specific questions. We're seeking legal recognition of the rights of island nations to a healthy environment, free from the adverse effects of climate change. We're seeking to establish a legal framework for holding states accountable for their contributions to climate change, and for providing compensation in the long term or reparations to island nations for the loss and damage they have suffered. And lastly, to set a precedent for other island nations and coastal communities to take legal action to protect their rights in the face of climate change. So down the line, I think these advisory opinions will really serve as the foundation for increased climate litigation and just more constructive international climate policies that are more inclusive and embracing of island perspectives, worldview, and more aligned with just approaches.
Thank you. I think that's really, I love how you've interwoven the history of you and of how that has motivated you, but really turned it into this purpose-driven collaborative effort of countries facing similar issues, and that you've chosen this path that is quite well paced out. It's almost well planned out. You know that if this, then this will happen, and so it can actually lead to action that is impactful and actually makes a difference. So it's really activism with purpose and action behind it. And thank you for sharing that. I'm sure we'll come back to some of the aspects that you've highlighted. Let me please now turn to Samira. Samira, let's turn to your story, because you represent World Youth for Climate Justice, of course, and so you bring an important youth perspective to this conversation. Can you tell us a little bit about your motivations and your hopes for being involved in this activity at this time?
Thank you for the invitation again. It's a real pleasure to be there with you. So as you already said, my name is Samira Ben Ali. I'm from also an island that is called Mayotte. It's an island that is in the Indian Ocean, in the Mozambique Canal, between Madagascar and Africa. And me personally, I think that it's the same reason as Naima, is that I was able to see the changes happening in my island in real time. So now I'm based in Paris, France, but I go back to Mayotte often because my parents live there. And from visit to visit, I felt like a strange sensation because when I went there, for example, I went to the same beaches where I went often, but somehow the sea felt depleted, the coral felt whiter, and even the weather has changed a little bit more. It's like more drought than ever. So I was trying to understand why this was happening. And from looking at it and from doing research, I could see that, oh, this didn't just come like this. This isn't something that happened because of fate, but this is something that is happening because of science. So when I was looking at those effects and I was reading the consequences in the long term, I was realizing that for my island in particular, but also for other islands and other territories in the world, this would mean a real disaster in the future if we don't do anything. I stumbled upon World Youth for Climate Justice when I was doing an internship back when I was doing a master in a little city named Caen on future generations. And I really felt connected with the different stories from people from World Youth for Climate Justice. This is a small organization that has grown a lot in a few years. And it all started in the Pacific with my brother and sister from the Pacific that live also the same, somehow the same consequences of climate change as I do, and that also see what is happening in their island is the same effect that is happening in my island. And I was really touched by their stories. I could really relate. And even if we were in different seas, I could see myself really working for this cause. And I also am a big believer in law and in the power of the people. So to me, this matched perfectly because with this movement, World Youth for Climate Justice, we are really trying to empower the voices of those that are not used to be heard. That is youth, but also people who are more marginalized, indigenous communities, and also women of color. So to me, it represented a lot. And this movement that was born from students has become something greater. It's trying to look at the law in a way that is more intersectional. And we're really trying to understand the consequences of climate change for the people, because at the end of the day, this is how we're going to feel it. And I decided to get involved in this organization in particular to really raise awareness and help participate for the people on my island in the understanding of what is going to happen. And to me, this decision in particular that happened at ITLOS was really encouraging, because it's really showing the way, and it's showing also the way for the different other courts that they need to make a lot of effort for our future.
Has seeing this decision come to fruition given you hope?
Yes, it has given me the hope. I didn't really know what to expect when I went to the tribunal. I'm also like a law practitioner, but I was told that I needed to be careful when I go to those kind of places because generally we can be a little bit disappointed. But I feel like the tribunal has really shown us a strong statement with this advisory opinion saying that we need to do more. And even if they didn't say much about human rights, which is one of my focus, I feel like they gave a big pathway for other courts, in particular the ICJ, to be able to take this upon themselves and really make a strong advisory opinion that will put human rights at the center of it, and that will put the calls of the people in the center of it.
Thank you, Samira. Yeah, I heard both you and Naima mention the human rights aspect to climate change, which I think isn't something everyone who's not so involved in the climate change issue thinks about. I need to recycle my plastic. I need to drive an e-car. I need to care about the bees, right? That's a very first world concern about climate change. But from the perspective that you bring and that Naima brings, it's like it is much deeper than that. This is about existence. This is about the continuation of lineages and families and heritages. And that was a very important point that both of you make. And I'm glad that this case has also helped to bring that to the forefront of the discussion. Thank you for your insights, Samira. Neshan, let's turn to you at this moment. You're an experienced and well-versed, of course, in the understanding of how the UN system works. So you have also a very important systems level view of climate change and of how these court cases and these advisory opinions can feed into kind of greater change and impact down the line. So maybe you could tell us from your perspective, not only your motivation, but what you see as the relevance of this advisory opinion for cases such as these related to climate change, human rights, indigenous rights, etc.
Thank you, Lena and Marie. A great pleasure to connect again with Naima and Samira. It's been almost exactly a month since we met in the immediate aftermath of the historic advisory opinion at the Tribunal of the Law of the Sea in Hamburg, which will remain, I think, forever etched in my memory as a very special and momentous occasion on what I would call the shift of the 20th century international law into the 21st century international law. So again, a great privilege, Naima, Samira, and keep up the good work. And I think this inspiration cuts across generations. And that's what I want to start with and then get to your question then on how both the UN system works or possibly how the UN system doesn't work and how would we really like it to work in the future. I think that's a transition passage of time. We are here at the beginning of the 21st century. And here I'll immediately begin with my storyline, which connects to my parents, including specifically my mother, who's a lawyer, who has followed the path of justice quite strongly and imparted on me the importance of integrity when it comes to application of the law in society, and that the law does not exist by itself within legal systems, but it serves for the people. And I think that's a key component of what the ITLOS advisory opinion is also all about. And building on what Naima said before, whilst we understand that an advisory opinion is not binding on member states or the stakeholders, for me, it goes far more than just a binding concept. It actually holds the moral authority, which brings together an effective implementation of international law in a broader spectrum. And I think that's what the opportunity offers through the tribunal advisory opinion. But here I would like to backtrack a little bit longer than my parents' generation to the generation of few Sri Lankans and others who actually pioneered some of this work. First is Dr. Shirley Amarasinghe, alongside a Maltese ambassador, also joined a Swedish ambassador called Arvind Pardo, and the Sri Lankan ambassador, Shirley Amarasinghe, known as the fathers of international law of the sea, set up the United Nations Convention on the Law of the Sea in the late 1960s and towards the end of the 1970s, which then paved the way for a unique tribunal to be set up towards the latter part of the 1990s. In fact, it was in 1996 in October when the Tribunal of the Law of the Sea started hearing its first cases. And I worked very closely with the founding registrar of the Tribunal of the Law of the Sea, Dr. Kumar Chitty, who is also from Sri Lanka. And this was an absolute privilege. Unfortunately, a few years ago, Dr. Kumar Chitty passed away, but in his memory and the work we've done, he's always impressed upon me that the law of the sea doesn't stand idle by itself as part of a subsection of international law, but it represents our whole planet. Scientifically, it represents almost 71% of the planet, which is covered by oceans and the seas. And the fact that we as humans depend on this and directly are interconnected to this is something that he was always talking about when we are discussing wider concepts for future generations, including a trusteeship. So I think it's in their memory and the decision which came out. Now, coming to the UN and the question, Lena, you pushed on how does this influence the United Nations. I think it's important to understand that the Tribunal of the Law of the Sea is not a UN organ. Unlike the International Court of Justice, which is the highest UN judicial body and the only UN organ outside of New York, the Tribunal of the Law of the Sea, based in Hamburg, is set up through a kind of a memorandum of cooperation with the United Nations General Assembly, despite the fact that the tribunal was set up under UN Convention on the Law of the Sea. I think that's an important distinction. And the fact that almost 50 years have kind of passed between the creation of the International Court of Justice in 1946 and 1996 when the ITLOS was created, that has also seen an evolution of international law and principles of common heritage of humankind, development of international environmental law. And here I bring the wonderful wisdom of one of the founding counselors of the future council, Judge Christopher Veeramantri, who was a former vice president of the International Court of Justice. And I'd be really interested to see Samira's versions on what she thinks about his opinions, which was written 30 years ago when he was a judge of the International Court of Justice. And briefly going through the wonderful submissions made by the draft submissions made by the World Youth for Climate Justice, I see Veeramantri being quoted life and all over the submissions of what he set out on principles of sustainable development law, principles of international environment law, more than a quarter of a century ago. And that influences the way the UN and the wider multilateral system works. And it doesn't stop there. The decision of the Tribunal of the Law of the Sea now influences the regional system, as Naima was pointing out. It also affects what's going on at the national level. It affects the wider environmental climate movement, seeking justice by young people or older persons in the case of what happened in Switzerland. It is bringing massive changes. And I think this is where the United Nations also will transition into kind of adhering to this new 21st century wave and development of international law. And the final point I will just end with is this example of consensus of international cooperation. Now, we know the 22 wonderful judges of the Tribunal of the Law of the Sea decided this opinion through consensus. And whilst there are separate opinions, everyone was agreed on this advisory opinion. I would like to connect this with the wonderful inspiration that Samira works with coming from the Pacific Island young people who moved the UN General Assembly, the highest decision-making body in the United Nations, to have a consensus resolution March last year to put the question of climate change to the highest judicial organ of the United Nations. So between a consensus decision of an advisory opinion of the Tribunal of the Law of the Sea and a consensus United Nations General Assembly resolution on the similar issue to put to the highest court of the UN, we have an exciting time for the evolution of the 21st century to put matters in our home right before it's too late. So I'll end here, but happy to come back on reflections on what Naima and Samira also has to add.
Thank you, Neshan. I think it's very important that you've helped us understand kind of the historical context of what is this tribunal and what is the law of the sea and where does it come from? Because that's also not something that everybody knows. And it's, as we can see with climate change impacting virtually every aspect of the ecosystem that we're in, it's very important to understand how this plays into the decisions being made on all fronts of the issues for mitigation and resilience in climate change. So thank you for that information. I think what occurs to me is that for all of you, this advisory opinion serves as a milestone in many ways, and perhaps for each of you in a little bit of a different way. And because COSIS was so instrumental in getting it over the line to the ITLOS for it to be even considered, I wonder, Naima, if I could ask you, how does this AO, now that it's come through, how does this impact your work? Does this change your trajectory? Does it present you with any challenges? How will you now take this win and turn it into more?
Yeah, I think what COSIS is grappling with now, in addition to supporting the member states and their submissions to other international courts and tribunals, is really empowering island governments, but eventually and hopefully all governments, to be able to utilize and implement and build upon what's been offered by the International Tribunal of the Law of the Sea. In terms of challenges when it comes to international law enforcement, is definitely where the rubber often hits the road. But as Neshan mentioned, it's really more about moral authority and speaking truth to that moral authority. And overall, we know that soft law in environmental law is a really valuable tool for addressing complex environmental challenges, building consensus, catalyzing action, and promoting cooperation among various stakeholders. And so, in terms of the challenges, I think there's always the struggle with a lack of enforcement mechanisms. And as Neshan mentioned, international courts and tribunals generally don't have the power to enforce their decisions. And this can really limit the effectiveness of legal decisions in bringing about tangible changes in climate policies and practices. The question is now, how can we build the capacity amongst COSIS members and later all stakeholders and governments to utilize and be creative with the guidance that's been provided by the advisory opinion. International courts and tribunals may also have limited jurisdiction over certain states or entities, particularly if they have not consented to the court's authority. And this can also limit the scope of legal action and the ability to hold all relevant parties accountable for their contributions to climate change. There's also political considerations that we are thinking about. International legal processes can be, of course, influenced by political considerations and power dynamics among states. And this can potentially lead to outcomes that favor certain countries or interest groups over others, inevitably undermining the fairness and impartiality of the legal process. I think perhaps the biggest challenge we are facing has to do with resource constraints. And these legal cases that are pursued at the international level and then hopefully operationalized at the domestic or even local level can be really resource intensive. They require significant financial, legal, and diplomatic resources. And this can pose a serious challenge for countries and marginalized communities who may have limited access to such resources. So I think what's quite special about this time, where we are seeing these requests for advisory opinions on climate change to international courts and tribunals, is that they are providing opportunities for there to be greater coherence between the reality of the climate crisis and that of our international legal system. I also think we should be looking at the importance of process as we seek outcomes that are more just, inclusive, and equitable. And these are conversations that we are having among COSIS members. So justice at the level of outcome is only established through the operation of justice at the level of process. And so at the collective level, justice is the practical expression of awareness of the fundamental truth that humanity's collective experiences are shared. And this necessitates a comprehensive representation of diverse perspectives at every level of governance for effective purposes. And so times of turbulence in particular present profound opportunities to redefine our collective values and underlying assumptions. And the challenges posed by climate change should really catalyze the adoption of inclusive governance practices and equitable community practices that unlock the full potential of human experience. So in a nutshell, the way I'm approaching this movement is, I think climate change and other major crises around the world are compelling humanity to recognize its singular existence as a species, and therefore its need for new patterns of organizations that are commensurate with today's needs. So the more international courts and tribunals respond to this need, the more aligned our international climate legal regime is with this fundamental truth, and the more it can serve us.
Thank you. It's quite profound, actually, what you've just said, and so eloquently and beautifully said, kind of the singularity of us all, the singularity of how we live, having the value-based discussion, the moral authority to push these issues through, and then to then carry them through into processes that are just. I mean, that's a huge mouthful to put it, very placatively. But it's really important, actually, what you just said, and that the fact that this advisory opinion can help move that entire moral justice, future generational agenda forward. I think that's a fantastic assessment of this, and I'm glad that that's what's come out of it. And one thing that you also just mentioned, you talked about kind of capacity building and the diplomatic efforts. You talked about it in a little bit of a different context, but in my head, I was then thinking about Samira and how your work as a grassroots activist, of course, with youth who are impacted by this and who are seeing this in their families. Now you have even maybe more justification for being more aggressive, but aggressive in a good way. But to go out there and say, hey guys, this is happening and these people are standing behind us. And so now we need to move. And so Samira, maybe to you, does this AO and this momentum now give you a new push for more action? Is this going to influence your work now with youth around the world?
Yes, definitely. This advisory opinion has given us a lot of hope, as I already said before. I think that now what we have to do is make sure that the people who are really close to those events, the extreme events, and are really close to the effect of climate change are able to seize and understand the impact of this advisory opinion so that they can use it for themselves. What we do a lot is that we try to raise awareness. We try to create a messaging that is really something that is going to impact a lot of people, and people are going to be able to read it easily, and we're going to be able to distribute it. We do that by doing a lot of collaboration, and we were able to grow because we did all of this collaboration. At the beginning, we're only students, and then we're able to we joined with a lot of CSOs, more than 1,000 CSOs were able to join this cause that we raised. And then we went to the highest courts in the world to plead our case. Now, what we really want to do with this advisory opinion is use it in a way that is going to be able to go to the roots, again, to the roots where we started, make it really clear that we need also to go more. And what we're also going to do with this advisory opinion, because now our eyes are also focused on the ICJ. So what we're trying to do is really talk with state and tell them that if they did not dare to be ambitious before, now that they should be more ambitious during the commentary phase of the ICJ proceeding, and also during the oral phase that will be coming soon in a few months. And we're telling them that, yes, ITLOS has recognized the need for best available science. Yes, ITLOS has also spoken about the due diligence, and it has spoken about cooperation and collaboration and the necessity for mitigation and adaptation. So we need to tell state that they need to be more ambitious, because this is about them, this is about the future and the future of their children. And we are also trying to make sure that this messaging that is brought by the ITLOS is not only that, but that they go further than that. We're also trying to push messages around intergenerational equity that has not been mentioned, but we hope that we will see it there also. So this advisory opinion has given us a lot of leeway for argumentation and for just pushing state to be more ambitious in general. And what we also hope with this advisory opinion is that we hope that we will be able to link the ICJ with the people, that we will be able to use this advisory opinion as another argument to bring people in front of the court and show them that this is something that they need to seize, and that the judges need to see it, that it started from the people and now it will also end with the people.
That would be really powerful, would it, to have a huge representation of people who are impacted and who care deeply, standing in front of the court and making those cases and arguments so passionately, as you've already done once, but now to come again. So we'll be watching that space very closely, for sure. Neshan, maybe last question to you. Samira just mentioned the ICJ as well. So there's more to come in this court approach to getting answers and solutions and processes underway. What do you see coming up with the ICJ case, or generally with public opinion? Do you see that this is a positive momentum going now? What's 2-3 things that you're looking for now in the next year?
Thank you, Lena. If I could add to what Naima and Samir already said, I think it's from initially an international legal point of view, it's definitely an exciting time to see this evolutionary passage that is looking at bringing different regimes of within international law to complement each other. And as well as word enforcement was also used in our responses. I will also use the word effectiveness of the international institutions. And that means, for example, how the advisory opinion of the Tribunal of the Law of the Sea speaks to the proceedings before the International Court of Justice. It's like how would the oceans inform a discussion on the earth, because the ICJ will have to go into deciding it for the whole earth, whereas ITLOS decided it for the oceans and the seas and the waterways. And I think this reimagined world of international law is quite exciting. But this is where what Samira said is also equally important. It is not limited to lawyers and judges connected to the international law. It's connected to the policy world, and the policy world is the peoples. And these communities that Naima, Samira pointed out who are affected and are considered in the terminology as most vulnerable. How do they perceive these decisions and opinions? And a conversation between what happens at The Hague or Hamburg and its implementation at the very local level is of critical value as we move into possibly a very significant year, 2025, which is going to be 10 years since the aspirational document of Paris Agreement, and celebrating many other aspirational aspects, which has been the kind of modus operandi for international law implementation over the last possibly 25, 30 years. How do we move from this aspirational back to an effective way of international law informing decision-making and policy-making? I think that's what has been the big question that's going to be asked of all of us. As opposed to 30 or 40 years ago, all the science informs us, which the law has caught up with, that we do not have another 30 years. And that's, I think, the other aspect. And unfortunately, with the current governance system, I'm a bit biased with this, but I do not think we understand the whole time aspect that well, the urgency that it is affecting certain communities in different parts of the world. Whilst there are people, including the climate movement, youth movements, and open persons movement, trying to bring this and alert it to the policymaker, the current governance model is struggling to come to terms with the time and the urgency and dealing with this issue. I think that's something that is absolutely crucial. And we are attempting through the World Future Council and other engagements, for example, the Summit of the Future, which comes up in September, to bring this understanding of what is it to consider future generations in decision-making processes. How can we inbuild or establish on voice on future generations at all levels of governance? And this is something the World Future Council has been lobbying from the very first day of creating the World Future Council. And whilst the advisory opinion from ITLOS is a massive contribution to this effectiveness, there is still a big gap that needs to be filled. And I hope the momentum that is going to, move towards using this international legal jurisprudence, but also the effective work of the work that Samira, Naima, and others are doing, build these coalitions across different groups of people and really build on indigenous knowledge systems and indigenous legal systems, which was championed by Judge Veera Mantri and brought it into the jurisprudence of the ICJ, 30 years ago. Is absolutely important. I can be excited as an international lawyer because we have these decisions, we have these processes going to the courts in Hamburg and at The Hague, but we really need to understand how it is implemented and brings about change, not only to those in different parts of the world and small island states, but to begin that conversation of effective change. And that's where I think a longer program of capacity sharing and discussing and storytelling is important about this wonderful work. Not be limited to the legal fraternity that Samira and Naima also represent, but also speak about and work. So that's what I think we need to do in the next 6 to 12 months as the exciting discussion, possibly at the ICJ on the climate change issue, which begin early next year.
Perfect. Thank you. Thank you, Neshan. Thank you for sharing how you see this continuing and going forward, and some other things that we can now keep an eye out for that might be coming up in the next 6 to 12 months. And I think a couple words that all of you said really stick with me, and I'd like to share. I mean, one is, of course, kind of the concept of intergenerational justice and equity, that this has helped put that to the forefront, and this is going to help make that more prominent in the discussion about climate change, mitigation, resilience, but also in the discussion where how are we creating solutions and who's responsible. And I think that's the next point that you made that I thought was very important is responsibility and urgency. I've heard that out of everybody's inputs here to this conversation, that there is a responsibility question and the urgency question can't be ignored. And these go together, right? And this has helped put that into the center and pushes this forward for action. And I really like the aspects that you've all drawn out on the moral authority, which can now lead to a more equitable and just process. Because as you all have pointed out, the process isn't always run with the best intentions. An international process, a legal process, the judicial system itself isn't always achieving the right outcomes, and the process doesn't actually give a voice to everyone who needs to have the voice. And this has seemed to turn that a little bit on its head and say, actually, now those voices are being heard and recognized, and it's pushing towards more impact and action. So thank you all for sharing your views and your personal stories and helping us put some very important stories to this international event, because this helps us understand it better and how it will actually trickle down into the lives of everyone. So with that, let me turn back over to Marie.
Well, thank you, Lena, and Naima, Samira, and Neshan. This has been very insightful. And similar to what Lena said, it also really struck me as a European mainlander to hear your story as a small islander. That makes me sense the urgency and the desperation to seek climate justice. And it really is time to act now and to make a change. And so I'm very much looking forward to 2025, because this is to be continued, as you all said. The fight will be taken up in Den Haag again. And Samira already mentioned the first public hearings will take place in spring in 25. And so I hope the best for this case, and that this really makes a difference. And for all of you listening to us, if you want to get connected and learn more about the case, please reach out to the World Future Council, COSIS, and the World Youth for Climate Justice. You will find the link, I suppose, down below in the box. And thank you so much. It's been wonderful to talk to all of you. Thank you.